When I sense something is wrong with the case, it keeps me up at night.
The jury's imagination goes all over the place.
And that this guy was setting him up to try and take his house.
Kick your client out of his own house.
And so then it turned into, well, how can we prove this? But there was one piece of evidence that he pointed me towards.
And then you tore it apart using AI.
And then that's just when I came out and hit him with it. Isn't it true that you're a convicted sex offender? Objection, objection!
He lied, so he opened the door. In my opinion, he opened the door.
I think any time that a client believes that he should not be found guilty in a case, I think that the jury really wants to hear why.
I gotta interject here because there's something you said that I was smiling over here.
So ChatGPT actually trains the natural intelligence, and I think that this is the greatest utility of the artificial intelligence.
Welcome to the Iron Gavel. I'm Chris Washington, a criminal defense attorney with over 17 years of experience. Today, we explore an amazing case of justice, a story where our hero faced almost impossible odds, but his client emerged victorious because of his strategic preparation and defense. Today's guest is attorney Zachary Miller from Florida. Zachary is one of those front-facing lawyers who used AI, specifically ChatGPT, as his personal assistant / co-counsel in several phases of the trial. As a lawyer, you will learn these powerful techniques pioneered by Zachary. As a member of the public, you will learn about cutting-edge technology that you can inform your lawyer on if you or a loved one is facing criminal charges. So let's just dive into this case together. The case we're going to talk about today, Zachary's client found himself in a serious case: aggravated battery with a dangerous weapon and aggravated assault with a deadly weapon. His client was facing up to 20 years in prison. The stakes were incredibly high, and we will show you step by step how the situation unfolded. But first, let's learn a little bit about our hero, Zachary. So Zach, tell us a little bit about yourself and your background.
First of all, thank you very much for having me here. It is an absolute pleasure to be here with you. I grew up in Youngstown, Ohio, and my undergraduate was in violin performance. After that, I decided I wanted to go to law school. So I went to Ave Maria School of Law, and that's in Naples, Florida. And I was barred in Florida after that. My very first job was in 2015. I took a contract job at the Office of Regional Counsel. The Office of Regional Counsel takes the public defender's conflict of interest. And I stayed in that job for almost 10 years. A couple years ago, I went part-time with that job and began taking private clients as well. Mr. Milazzo, I had a case with him before as a court-appointed case, and he liked how I handled that case. So in that first case I had, it ended up getting pled from a felony down to a misdemeanor. So when he accrued this case, he wanted to hire me right out of the gate. And so that's what happened, was he ended up hiring me, and I ended up taking his case to trial, and we had a substantial victory.
So we're definitely going to get into all the details of that, your strategy, the tactics, how you use technology, all of that. So I want to know, though, for the audience, what inspired you to become a criminal defense attorney?
I had heroes in the community, you understand, in the community of Youngstown. There were people who I looked up to, and these people were criminal defense attorneys. And I saw how they were respected in the community, and I saw how they did good for the community. And I wanted to be like that. I wanted to be a person who could go into the community and be a person who people came to for help. And as a musician, I didn't have the kind of skills that would allow me to make these tangible differences in people's lives. I could entertain people. I could bring momentary joy to them as a musician, but I couldn't provide them the kind of service that would provide this meaningful change of life. And so I wanted to develop those skills. Going to law school gave me the preparation to enter the vocation of the public defender. And, I call myself a public defender with lowercase p and a lowercase d because I didn't work for the official public defender's office. Obviously, I worked for the conflict counsel's office. But it was the same thing, court appointed indigent representation in the criminal courts. In nearly 10 years of doing that, I was able to develop a lot of these skills that I had admired in my youth from these gentlemen who were able to make a difference in their community.
What would you say is the thing you're most passionate about in doing criminal defense work?
Making a difference in people's lives, being the person who people can trust, and being the person who fights for another individual who found themselves in a situation that demands justice. And it demands a person who is able to adequately advocate for them to achieve that justice. And without this resource, the person might be stuck with an injustice that would negatively change the entire rest of their life.
That's so true. A lot of times, what we do, we're looked at as the bad guys. People come to a criminal defense lawyer, they're down on their luck, they need help, they're in trouble. We're usually the only person standing in their corner. I certainly understand that. I like to ask this question. There are so many lawyers that do what we do. So, what do you think it is that sets you apart in this area of law?
It's probably my choleric personality. When I sense something is wrong with a case, it keeps me up at night. I am compelled out of bed at 9 p.m. and I have to go to my computer and I have to work the case out. And I have to be doing this up until 2 a.m. Or if I'm not doing it at night, then I'm up at 3 a.m. and I'm doing it in the morning. So I think that what sets me apart from many people is that I put in the extra hours, but I don't do it out of ambition. I do it because I have this inner compulsion and I can't do otherwise.
You can't turn it off. I'm the same way. I cannot turn it off. If it means lack of sleep, I had a trial the first week of February, a murder trial, and I'm pretty sure I had the cold or a flu or something. And every night I would take Theraflu to nighttime, and in the morning I would take Theraflu to daytime, and then midday I would drop some Alka-Seltzer in a bottle of water. But, we just have to show up because we're it for these people in a lot of situations.
Yes, sir. And I'll tell you, the way I do it is I have a constant drip from the time I wake up until about 4 p.m. Constant drip of hot water with Earl Grey tea, a little milk, and a little honey. Never stops.
So, the case you're going to tell us about today, why do you think is important for people to know about this case?
Well, I think that artificial intelligence, it's in its infancy right now. It's been around open to the general public since about 2022. And I think that the defense bar has been very slow to adopt it. I think a lot of people are scared of it. I think a lot of people have some very valid concerns with it. But I kind of dove right into it, and it was instrumental in helping me win this most recent trial. So other than the AI aspect, it was a trial a lot like other trials. It had many of the classic facets of a compelling trial. But the AI component, I think, is the part that is important for other defense attorneys to hear about because it's what changes the game, and it's what levels the playing field, and it's what increases access to justice for our clients. Okay, because now if we can properly utilize artificial intelligence, we can achieve excellence on a flattened curve. You see, artificial intelligence can provide the type of training that before now was only accessible to people who were willing to spend thousands and thousands of dollars, go to immersion camps, seek out the most talented consultants in the world. And now we have the kind of advice that we get in this kind of situation at our fingertips. And all we have to do is know how to ask for it.
That's absolutely true. And I know you're ready to teach people about that. I'm ready to learn. I use AI daily, but there's so much and it's moving so fast and changing so much that we got to stay aware of what's happening. But we also got to get educated because it's powerful in pretty much everything we do. So I want to know, how do you typically approach? We're going to break this into two parts because since you've incorporated AI, how would you typically approach a criminal case prior to you implementing AI, and how has AI changed your preparation now?
Okay, so there's a lot of different artificial intelligence products. And one of the most compelling concerns for an attorney who uses AI is confidentiality. There are products that claim to have increased confidentiality, but those products also have an increased price. And it's hard to try every product, and it's hard to find out which products work the best and which ones don't. I will have to admit that I have not tried all the products. In fact, I have stayed with the classic ChatGPT. Everything that I've read is that ChatGPT, in many ways, is still the best. Okay, but I can't say that through experience. But what the problem with ChatGPT is that it doesn't have the confidentiality safeguards that a lawyer would really hope for. I contacted the Florida bar about this, and I asked them about what I could do and what I couldn't do with ChatGPT. I was very surprised to learn, and many defense attorneys might be, you can't even take a public record police report that you received in discovery and load it into ChatGPT without breaching confidentiality. And that's because the rule is very strict. Anything that you receive in the course of representation, confidentiality attaches. And I was surprised because a police report's public record. You can just go on the internet and grab it. You can ask the police department, hey, please send me a copy of this police report, and anyone can do that. But as an attorney who receives it in the course of representation, confidentiality attaches. So the solution to this was to create a document. And what the document does is it explains to the client what I want to do with his discovery, that I want to put it into this ChatGPT and use the power of ChatGPT to help in representation. And usually, this is something that the client wants me to do. Okay, at this level, I can imagine there's other levels where there would be a heightened level of secrecy, and maybe you'd be worried that somebody would be on the other end watching. But at this low state level, the client really wants me to do this and wants me to utilize the power of ChatGPT. So I have to explain to the client in this document what the risks are, who might be watching it, what might happen with this information. And what I call it is a waiver of confidentiality and informed consent. So the client essentially waives confidentiality as to the discovery. Okay, and I also tell him that I'm going to be strategizing using ChatGPT. And those strategies that we work on might lose some confidentiality. What's the worst that could happen? If we use our imagination, perhaps there could be a data leak. We're not aware of any of this having happened to any attorney before using ChatGPT, there being a data leak, but it's within the realm of possibility. And quite frankly, it's within the realm of possibility with any kind of cloud computing software you use, and it's industry standard to be using cloud computing software. What's another thing that could happen? Well, maybe we could imagine the state attorney saying, oh, we know this lawyer's using artificial intelligence. Well, let's subpoena OpenAI and see if we can get his work product. Never heard of this actually happening before. We don't really know what would happen if it would.
Somebody's going to try it one day. I do believe that.
No doubt. So if this was a high level federal case, I'd be much more hesitant to use ChatGPT because, we don't know who's watching.
We know they're watching. We just don't know who it is
Yeah.
that's watching. What would you say are some of the most common mistakes people make when they're accused of a crime?
Oh, saying too much to the police. That's probably the biggest mistake. I don't think that happened in this case. Talking to people before they talk to their attorney, giving permissions, waiving their rights, such as search permissions, thinking that they can talk their way out of being arrested. Generally, just being ill informed, and it's natural. Unless you have worked with the system like defense attorneys have, it's natural to not know the way things are going to work and the way things are going to go, and to fall in one of these traps that are kind of inherent in the criminal justice system. What do you think I'm leaving out?
You've covered the most important things. Saying too much to the police. They have a Fifth Amendment right to remain silent. Most times, I know in Louisiana you're required to give your name, address, and if you're in a car, registration and proof of insurance. And I tell people, if they ask where are you coming from, you're not required to answer that. Where are you going, you're not required to answer that. The biggest thing is certainly that part, talking too much, because everything they say can and will be used against them, and a lot of times it gets twisted. The cop will write in the report completely different interpretation of what the person says. So the safest thing is to be quiet, talk to a lawyer first before you talk to, even before you talk to family members and friends, you need to talk to a lawyer because there may be some things you can't say to those individuals. We got the confidentiality sorted out. So let's jump into the case. Give me a little backstory about your client, the facts, the allegations, and then I want you to kind of weave in how you use AI at different stages of the case.
As you're aware, it's relevant at a trial, the backstory of the client. And so, one of the things that I was able to bring out as a little bit of backstory is that my client is a honorably discharged service veteran. And that came out. And I incorporated that, became a feature of my closing argument. My client had worked in the construction industry. He had purchased a couple of trailers, and he met the person who was characterized as the victim, but who I refer to as the accuser. And he met the accuser at a restaurant, a breakfast restaurant, and they became friends. And I think it was first that my client needed a place to stay, and he moved in with the accuser. But then my client ended up purchasing a trailer, and the accuser moved in with him. And then my client had another trailer. They both moved into this other trailer. And in the meantime, the accuser was developing into something of a nuisance. He was bringing all kinds of women over, all kinds of different people who my client didn't know. And it was affecting my client's quality of life. There was something with the truck where the accuser worked on my client's truck and drained it of transmission fluid, didn't tell the client, and ruined the truck. There was some testimony about how the accuser had talked about something that's called tricking people out of their home. That's where basically you use sort of some social engineering techniques to try and obtain possession of another person's house. So what happened in this case was that my client had begun asking the accuser to leave the trailer, to go find somewhere else to live. The accuser wasn't going to go. He was saying things like, well, according to the testimony, he was saying things like, you will have to evict me. He was doing other things too. I think the day of the incident, my client testified that the accuser sucker punched him before the incident happened. He sucker punched him because of all this backstory that was going on. Because, what are you going to do about it? You're going to have to evict me. After the sucker punch, my client got very angry and he came out into the living area. Now, the accuser was living in the living room, okay? So it wasn't an enclosed bedroom. It was a common area. And my client came out. He had a baseball bat and he had a knife. As another piece of backstory, there's testimony that a couple weeks earlier, the accuser had pulled a knife on my client, and my client had called the cops on him. But then it de-escalated. My client promised that he'd be good. Not my client. The accuser promised that he'd be good, and the client decided not to press charges. But this night, my client felt that it was necessary to come into the living common area with a baseball bat in his hand. He wasn't holding it up like he was ready to slug or something like that. It was just held down at his side, and a knife. The way it went, both parties agreed that my client took the knife and held it to his neck and said, all right, big man, jam it in. Go ahead, big boy. What are you going to do? Okay. And this is where the account begins to diverge. So the accuser said that my client then took the knife and slashed at him, violently slashed at him. And in doing so, cut the palm of his hand. Okay. And it was a very small pinprick kind of cut, very small cut. Everybody agreed. The police agreed. It was just this very small cut. My client said that no, he didn't slash, that the accuser grabbed the knife. And then as soon as he grabbed the knife, then he says, there's another person there. There was a witness. except the witness did not show up at trial. And the accuser tells the lady there, okay, we got him. Call the police. Okay, so, and the theory of the case was that he grabbed the knife, knowing that he would be able to call the police and paint himself as the victim, obtain a restraining order. So now my client, who owns the place, cannot return. Okay, and so now the accuser's not getting evicted anymore. Now my client is in jail, charges of aggravated battery with a deadly weapon, to wit, stabbing this person with a knife. And that's how it played out. The police came and they went through the house. They interviewed the accuser. They interviewed my client. The only part that was caught on video was the interview with the accuser. The interview with my client was written down in a police report, non-verbatim, and it was written down maybe a few hours after the incident. That became a feature of the trial because when the police came in to testify, they said that my client admitted to poking him, and they said that my client had admitted to trying to provoke the accuser. But I was able to get them to admit that they didn't actually have an independent recollection beyond their police report of what was actually said, and that these characterizations might not have been exact words, but rather their own impressions. I think that kind of helped disarm those party admissions.
Your client, how much time was he facing, and how long did the case take from start to finish? The reason I ask that is that a lot of times the public in general don't appreciate how much time some of these offenses carry. And then part two is they really don't understand that criminal cases oftentimes take a while to be resolved. So if you could just touch on those 2 points, that'd be great.
Yes, sir. Originally, he was charged with aggravated battery of a deadly weapon, aggravated assault with a deadly weapon. Aggravated battery with a deadly weapon is a second-degree felony carrying a maximum of 15 years. And aggravated assault with a deadly weapon is a third-degree felony carrying a maximum of 5 years. The aggravated assault charge was subsequently dropped. There was subsequently no info. Okay, but very close to the eve of trial, they resurrected that charge. They refiled it.
That's
Yeah.
dirty.
Well, it was what it was. I filed a motion. I filed a motion to dismiss it based on speedy trial. And, it's a very complicated rule, and the judge could have gone either way. And the judge decided that because two charges were stemmed from the same course of conduct, therefore reintroducing the charge after the speedy trial had elapsed was not barred. So that's what the judge ruled on. And that was a motion to dismiss that we had before the trial. So the score sheet with both charges, aggravated assault with a deadly weapon is level 7. Okay, so Florida has this score sheet system. Okay, and what they do is they take all of your prior charges and give them a certain amount of points. And then they take all of the current charges and give them a certain amount of points. And they have one that's the most serious charge is scored the most heavily. Then all the additional charges are scored on a lighter scale. And then your prior charges are also all scored on even lighter scale. And then there's certain things that can aggravate the score. What they do with the score, then you get this number of points. And then there's a little calculus that will arrive at a minimum amount of prison that the person must serve if he is found guilty. And there are ways to get below this, but you have to prove what's called a downward departure. You have to prove that there are good reason for the judge to go below this minimum sentence, and it's very rare to get a downward departure. Okay, so that's how the Florida score sheet system works in a nutshell. There's a lot more to it. That's how it works as it was relevant to this case. He was scoring to more than 3 years in prison. If he would have gotten guilty on both charges, minimum would have been 3 years in prison, a little bit more. Yeah, how long did the case last? Okay, so arrest date in March and trial in January. He was out of custody for a little bit of that time and in custody for a little bit of that time.
Would you say that's typical, nearly a year from start to finish, or was that a quick trial?
Especially if it's going to trial, that's typical. If it's only going to be a plea, they have time goals. So cases like this, 9 months probably. I think 6 months is usually a standard time goal. 9 months if you have reasons for continuances. Sometimes you set it for trial, but then they don't have time to get to your trial that month, so it gets rolled to the next month. So yeah, this is pretty typical.
I want to hear about the initial meeting with the client. Any initial doubts and fears that you had, and any initial doubts and fears that he may have had.
So he wanted someone who would go to trial. He wanted somebody who wasn't going to encourage him to take a plea. And so I asked him what his defense was. And he told me his defense was consistent. His defense was the same thing as it was in the police report, that this guy had grabbed the knife and that this guy was setting him up to try and take his house. And so then it turned into, well, how can we prove this? And he gave me a list of names to go interview and investigate. But a lot of these people were kind of transient. And I was able to talk to some of them. Some of them didn't want to get involved. Some of them I couldn't track down. But there was one piece of evidence that he pointed me towards. And this, I think, became a feature of the trial. And it was relevant. And that piece of evidence was that his accuser was a registered sex offender. And the reason that became relevant was because, and I made a motion in limine about this, I put everybody on notice that this was going to be an issue. I had case law ready. So all I had to do was set the evidentiary predicate to get this admitted. And the reason that it was relevant, normally prior bad acts don't come in at trial, okay, because they're irrelevant. We just want to know what's relevant to the situation here, what's relevant to whether or not this crime was committed. Well, the accuser being a registered sex offender was relevant to whether this crime was committed because it showed motive, okay? And as we all know, a registered sex offender has a very hard time finding a place to stay, has a very hard time finding a place to rent. So now we have a motive for this guy to avoid eviction and to kick my client out of his house so that he doesn't have to worry about finding a new place to stay.
Kick your client out of his own house, right?
That's right. My client owned the house. My client wanted the registered sex offender gone, and the registered sex offender didn't want to have to deal with that, so he figured out how to make things work in his favor. And the way he did it was he waited till my client got irate, waited till my client had the knife in his hand, reached for the knife, bap, now I got it, call the cops.
What kind of evidence did the prosecution actually have against your client that may have been concerning to you?
The trial was the victim. They had the baseball bat. They had the police, and that was essentially their trial. So they weren't able to bring any of the witnesses. They had a 911 call, and they had a police video of going through the house. Okay, so that was what they had. And I think in the end, it was more or less a he said, she said.
What was their strategy in a case like that, where it's basically your client's word versus the other guy's word? What kind of strategy did the prosecution develop, and how did you deal with that strategy?
Yeah, their strategy was very straightforward. Ask the cops what they saw, ask the accuser what happened, let the accuser tell his story, and hopefully it persuades the jury. That was the strategy as best I could.
And then you tore it apart using AI. From what I've learned was instrumental. At this point, I want to know everything about how you use AI to, I guess, attack the prosecution strategy as well as help develop your own strategy.
So I'd upload the discovery into the AI. And there's certain things that you have to be careful about when you're doing this. It's not just confidentiality to your client. There's also there's certain laws like Marcy's law that imposes a duty to also keep victim information confidential. So you have to be very mindful of that. Even if you get your client to waive their own confidentiality, you still have to be mindful of these other duties. But being mindful of that, I uploaded the discovery, copy and paste reports, making redactions where necessary. I put in the victim's written statements. I summarized what I heard on the 911 call. Then I just started having a conversation with the AI. I started talking about, okay, so what is the prosecution's best strategy here? How does the prosecution win? Okay, so how does the defense defeat these things? What can defense do? So now we're developing a theory of the case. Now we're developing counter theories and what evidence will be produced and how that evidence will be counteracted. Okay. And so then what I did was simulations. So each witness that I anticipated, the AI now had their statements. So the AI had a good idea of the kinds of things they were going to say. And let me tell you, another thing I put in there was the depositions. We did depositions. And so that also helped the AI get a real feel for how these people talked and how they thought, and what kind of facts they were going to be held to. So, with that in mind, I started running nation simulations. So, I would ask the artificial intelligence, okay, now you are going to be the accuser. And the first thing I want you to do is write out how you anticipate the state's direct examination to go. And once that's written out, then I want to take over and I'll begin cross examination and you be the accuser. So that happened. And it wrote out the direct examination. And, let me tell you, it's just scary how accurate these things are, both in what the state actually did for direct examination versus what the artificial intelligence anticipated, and in what the victim's actual responses to my cross examination was, as opposed to what the artificial intelligence anticipated. Okay, so it gave me this opportunity to practice cross examination, to practice making mistakes. And that feeling when you ask a question and you realize, oh gosh, that wasn't the strongest question I could have asked. Well, I got that all out of my system ahead of time. Okay, and I got to see what kind of answers I get. And then I got to ask the artificial intelligence, okay, so tell me how I could have done that better. And I was able to benefit from that advice. So when I actually went into cross examination, my strategy had been honed into a fine, sharply tipped sword.
I got to interject here because there's something you said that I was smiling over here, almost identical. Have you heard of NCDC, National Criminal Defense College?
Aren't they one of the ones who do the summer camps?
12, 15 years ago, it was in Macon, Georgia. It's primarily in Georgia. They have this document. It's called the NCDC Theory of the Case Worksheet. So I actually took their document and I asked ChatGPT to help me create questions based on this document that I can use to analyze the case. Number one, your theory of the case and defense position. And then here's the prompt. Based on the information in these documents, what are the possible theories of the case that could be used to defend client? Analyze these documents and identify the strong arguments in favor of the defense. The next question is, why do you believe this is the best theory of the case? And it gives me 7 questions I can ask. And it goes on. I won't go through the entire list, but I'll gladly share it with you. But it's 9 different questions, and each one of the questions have a minimum of 6 sub-questions. So I run this, when I get a case, I run all of these questions, and I have so much data to work with that it's amazing. It truly is amazing.
So and I love documents like that. I love systematizing case preparation. So I'd love to see that document.
I'm going to email it to you. Everything I have, I tell people is to share. I interviewed a lawyer last night, and then last week I interviewed a lawyer, and we got on Zoom for an hour afterwards because I was showing him how to do some stuff in ChatGPT. But yeah, I'll gladly send you this. And I have some other ones. I have 100 prompts designed to dissect every facet of a criminal case, general questions, questions to ask if you want ChatGPT to create you a timeline. I think I'm a little bit obsessed with it, but at the same time, I realize the value it provides. It's like having co-counsel without having co-counsel. You use it, you develop your cross, and I want to know the cross you developed using ChatGPT, how did it go in real life when you actually applied it?
Well, in real life, the judge said to me that I was going to have to establish an evidentiary predicate to introduce the convicted sex offender status. And so the way I did that is I started asking this accuser questions about, did he think that he'd have an easy time finding a new place if he was evicted? And he said that, well, no, I don't think I will now that I have an eviction on my record, because in the meantime, my client actually had filed in court for an eviction. So now that he's put an eviction on me, it's going to be a lot harder. And I asked him, so is that your greatest difficulty in finding a new place to stay, is that you have an eviction on your record? And then he backtracked even more. He said, no, I'm not going to have any difficulties. And then that's just when I came out and hit him with it. Isn't it true that you're a convicted sex offender? Objection, objection.
He lied, so he opened the door. In my opinion, he opened the door.
The judge agreed, and the judge also used the term that I threaded the needle. So yeah, so it was let in. I was allowed to ask the question. Then I tried to get into how severe was the crime. That shocked the judge's sensibilities. It's just like, please don't, please don't. And I respected that, and I think that it was okay to leave it at that, because I think that when that question is unanswered, it leaves it to the jury.
The jury's imagination goes all over the place.
But it wouldn't have been any better if he had actually come out and said it.
I tell people a lot of times, sometimes leaving something unanswered is more powerful than actually answering it, because people are going to form, God only knows what image they form in their mind as to what he may have done. It could have been, something that's a lot of people would have thought wasn't that serious. However, because it was unanswered, their imaginations probably ran wild, I would say.
So anyways, that's how that went. That was probably one of the climaxes of the trial, was getting that out. And then it was my case in chief, and all I did was I put the client on the stand, let him tell his whole life story and let him talk about what happened. He got very impassionate. He was angry. He was angry at the state for what they had done to his life. His passion was palpable. It was so palpable that the judge had to reprimand him. The judge had to send out the jury and admonish him and tell him that if he continued in this manner, that, maybe he'd be ejected. And I had to tell him, okay. And when they brought the jury back in, I said, let's practice here, okay? And I want you to take a deep breath before you answer my question. And so then I asked him a question that was designed to make him angry. And he started getting a little bit angry. And I said, okay, let's try one more time. Before you answer, take a deep breath. And I did this in front of the jury.
That brings me to an interesting point. There's some people that believe a client should never testify. Then there's some, like you and I, who, in the right situation, we know or feel that if we're going to have any chance of winning, our client has to testify. So what is it about your client and the facts in this case that led you to believe it was imperative that he take the stand in his own defense?
I think anytime that a client believes that he should not be found guilty in a case, I think that the jury really wants to hear why. And it's very difficult to explain to a jury that he has a right not to talk and not to hold it against him that he didn't talk. Even though it's a constitutional right, I feel that it's very difficult to explain that to a jury, and I think it's much more persuasive to a jury if they can hear the client's side. So let's say that maybe he has a past that's going to come out at trial. And if that's the case, well, then you're open about it, okay? And you talk about the circumstances and you talk about your rehabilitation, okay? And we did a little bit of that at the trial. We talked about his struggle with drug addiction and about how being in jail was in some ways a good thing for him because it allowed him to get clean. And so, I think that the jury, in order to find somebody not guilty, they really want to see that it's a human being. And in order to see that it's a human being, they need to hear your side of the story. And in this case, I came in with the strategy of hide nothing. Okay, so very often there's motions we can make. I'm a big fan of motions to suppress because sometimes you can knock out key evidence and get the case dropped. Okay, but when you're going to trial, okay, I don't want the jury to feel like I'm hiding something because then they think I'm a liar. Okay, so for instance, there was a 911 call that had all kinds of excludable material and the state wanted to exclude it. And I said, no. I stipulate to the absolute admissibility of the 911 call. Absolute admissibility. Okay, I didn't want to leave anything out. And then a lot of the stuff that the state would have tried to exclude actually helped me. Like, for instance, this accuser was trying to make it seem like my client didn't actually own the trailer, but in the 911 call, he refers to it as his trailer. Another thing was the police video. I stipulated to absolute admissibility of the police video. Every single bit of it. I didn't want any of it cut out. Okay, because the police were going around and you could hear him saying, gosh, that's a really little pinprick. That's a really little wound.
You
Yeah.
definitely want that in.
Yep, absolutely. So I didn't give the state any grief about admitting it. I didn't even make them admit it through a witness. I just said it's absolutely admissible. Just give it to the jury. I think that wherever that strategy is viable, it's a good strategy because it builds trust. And it's not going to be viable for every case, but this was a case where it worked.
So we get all this evidence in, and your client testifies. How does he hold up under cross? I don't know if we stated this. Did you use ChatGPT at all to help prepare your client for cross examination?
Only in the sense that I used ChatGPT to help prepare me for what the state was going to bring. But it was a direct conversation between me and the client. Okay, here's what they're probably going to ask you about. Okay, and yes, the client was ready, and the client reacted with passion. He reacted with authenticity.
Now, was this a case where you had to bring in your experts, private investigators, scientific analysis, or was this just one of those two opposing versions, and which would the jury believe?
A very simple case, but with high stakes.
That's right. After you put on your case in chief, does prosecution put on a rebuttal case?
They sure do.
Tell me about the prosecution's closing argument, and then I want to know about how or you may have used ChatGPT to help you prepare for the prosecution's closing argument. I'm assuming they go first and then you go second. Is that how it works in Florida?
It is.
Okay, so did you use ChatGPT to help prepare your closing argument?
Yes. So what I did, I had all the facts of the trial fresh in mind, and I just typed them all out. Here's what came out at trial. Here's what this guy said. Here's what this guy said. Here's the evidence. Here's the arguments we made. And I typed the whole thing out. And then we have certain jury instructions, okay? So we have jury instructions that define reasonable doubt and that explain that reasonable doubt can come from facts and evidence, conflicts in the evidence, and deficits in the evidence. Okay, so those are three places that reasonable doubt can come from. And this is what the jury is going to be using to guide their decision. So I upload the jury instructions into ChatGPT and I say, okay, based on these three things, I want you to, and based on what I just told you happened at trial, I want you to enumerate for me every single reasonable doubt as to each element in each charge. And I also uploaded the elements of the charges because those are also jury instructions. And
That's right. How long would it have taken you to compile that the old fashioned way that we are accustomed to using?
I'm not so much worried about how long it would have taken me. And yes, I would have been felt pressed for time. But what I'm even more worried about is the things I wouldn't have thought of.
That's right. That's a fact.
Yeah. So I asked it to do that, and I asked it to analyze each reasonable doubt. And then I asked it to give me a blurb, a way to frame it to the jury that will be persuasive. Okay. And this product was absolutely gold because, I took it up as it was my notes and I actually read it. And I was watching the jury as I read it and the light bulbs were going off. It was just amazing. And what else it was doing was it was training my own natural intelligence in the sense that now I was seeing this is how it's done. Okay. I was conforming my own habits to the way that I was now being taught in real time how to effectively do this in a way that went beyond the way that I had been used to doing it. So it was training me and increasing my skills. And these are things that if I lost access to ChatGPT tomorrow and had to go to trial, I could still take with me. So ChatGPT actually trains the natural intelligence. And I think that this is the greatest utility of the artificial intelligence.
I'm glad you said that. I've never heard anybody say that, but I agree. You said there's a school of thought or people that believe it's going to replace natural intelligence. It can't. I don't think it can. It's dependent upon us, but it certainly can and will and already is improving us. And I think it will continue to do so. So, yeah, it certainly enhances and trains natural intelligence. It's not a replacement. It's just not. But it works, right? It worked in this trial for sure.
Yeah, it really did work. I don't think I can overstate how well it worked. And I think, I want to encourage every defense attorney to start using it because it's changing the game.
I want to hear about your client when, he was facing a lot of time in prison, even on the low end. I tell people's like, oh, he's only going to be gone for a year or 2 years or 3 years. And I always say, look, if I had to go to prison for 3 years or 1 year, I don't know who's going to feed my children, who's going to pay my mortgage, who's going to do all these things that we have to be able to work to maintain. It gets undermined that it's not a lot of time, but even if it's not a lot of time, it's still a major disruption to a person's livelihood. Tell us how your client reacted when the verdict came down.
Okay, so the verdict was not guilty as to aggravated battery with a deadly weapon. As to aggravated assault with a deadly weapon, he was found guilty of a lesser included charge of improper brandishing. Okay, now that's a misdemeanor, does not carry the score sheet. His sentence was 7 months probation.
I want you to explain for the audience what a lesser and included offense is. Do y'all call them responsive verdicts? We call them responsive verdicts.
No, we call it lesser included offense, and there's two types. There's mandatory and permissive. Mandatory lesser included is defined in the jury instructions. It's defined by the Supreme Court, and it must be included in the instructions. Permissive is a lesser included. It will be subsumed by the greater charge, meaning the elements of the crime are included in the elements of the greater charge. But you have to request that it be included, and you have to make a good argument for it to be included. Improper brandishing is a mandatory lesser included. So it was in the jury instructions that if you don't want to find him guilty of aggravated assault with the deadly weapon. Also, this term assault has different meanings in different states. Okay, so in the state of Florida, battery means you hit him. Assault means you scare him. Okay, so they're both intentional crimes. All right. Whereas improper brandishing just means you showed him the weapon, you pulled it out, you probably shouldn't have done it. It was rude. In fact, that's part of the jury instruction. That's part of the definition of the charges. He did it in a rude manner. And yeah, he did pull out that knife and held it to his throat, and that's not something people normally do. So I could see how the jury decided to find him guilty of that. So they were given the option to find him guilty of that. If I would have had my way, I would have excluded those jury instructions. I would have said, nope, just find him guilty of the main charge or nothing. But I didn't have that option because it's a mandatory lesser included.
Was this the first trial you've had, first jury trial you've had where you use AI throughout different phases of the trial?
Yeah, this was the first time I was able to go all the way with the AI.
Is it fair to say you'll continue to use it going forward?
Wherever clients give me permission to do so, yes, I think that it's changed my practice.
In the realm of criminal defense, can you even envision a situation where a client might say no, especially when guys like you and I know this stuff is amazing and can help in essentially any case we have?
Yeah, certainly. I think that I could imagine maybe a client who has a high level of paranoia wouldn't want you to use it.
This has been great. Did I miss anything?
I think we essentially did it all. I also used some AI for voir dire, and that was fun. I asked the AI, okay, what's a good question to ask to figure out if anybody's anti-landlord, if anybody has issues with landlords. And I asked the question, and I actually got a guy who raised his hand. Yeah, I hate landlords, so he was out.
Landlords have to make a living. Landlords have to pay for repairs. It's a lot of work. I have 2 Airbnb properties, and they are a lot of work. But even my home that I'm in right now, look, I'm the landlord of this, and the kids break stuff, I have to fix it. It's a real job, not to be undermined. But that's great. So you use ChatGPT in voir dire or jury selection. Did you use it for your opening statement?
I used it to prepare my mind to make an opening statement. It's not like I printed it out and read it.
Right. You used it to help prepare the case and present different scenarios. So direct exam, cross-examination, closing argument, you use ChatGPT to some extent in every part of your trial.
So, and there's one last thing I'd like to say about artificial intelligence, because there's 2 ways to use it. And I see a lot of people want to use artificial intelligence to relieve their workload. Okay, so to do their work for them. And that's not the way you use it. The way you use it is you do all the work you're going to do anyway, and then feed it to the artificial intelligence, and the artificial intelligence will enhance it. It will make it go from 7 to 9, and then you keep recycling it. It's to enhance your work product, not to do it for you.
And that's why I say it won't replace us. It can't replace us. It'll improve us. And some of the stuff we'll learn, like I'm sure some of the questions is spit out to you, or you're going to internalize them and use them at some point in the future. So you are in Florida. What city?
Fort Myers.
What's that near? Is that a big city, or is it near a big city?
Mid-sized city. It's the biggest city in the area, with Cape Coral, Fort Myers metropolitan area, getting close to 1 million people in the metro area. It's about 1.5 hours south of Tampa and 1.5 hours west of Miami.
So if someone found themselves in your area and in need of a criminal defense attorney, how would they find you? How would they reach you?
Oh, just Google search attorney Zach Miller. Zachary Miller, Fort Myers, Florida. The Florida bar has a very easy way. It'll come up on Google under the Florida bar. Attorney Zach Miller, and my cell phone number will be right.
I Googled you and I saw that information.
I truly enjoyed this, and thank you for having me.
Same here, man. You have a good evening. That was pretty amazing. We have a lawyer who used AI to essentially solidify his client's case, and his client walked out scot-free, not guilty, found guilty of a misdemeanor, but that's nothing. This is important, people. This is important for lawyers. This is important for members of the public. It's a tool. ChatGPT, Google Gemini, Google Notebook LM, Claude AI. These are tools. They're not to replace a lawyer. Don't think you can go on ChatGPT and represent yourself. That's a bad idea. However, give this information to your lawyer if he or she isn't on the cutting edge and paying attention to what's happening in AI, because it truly can and will enhance the preparation of any legal case. That's it. Stay tuned. I'm going to continue bringing lawyers on, bringing people on, getting information that we all can use, or whether it's for ourselves or a loved one who encounters a situation like that. The Iron Gavel, signing off. Peace.